Every day in the USA, people find themselves in court.
Please state your name for the record.
Dimitri.
All right, this is case number 26-2005 FY. The people of the state of Michigan versus Devin Theodore Dimitri. Mr. Dimitri, did you have the opportunity to meet with somebody from the public defender's office today?
Yes.
I also have a praxis in front of me. It looks like you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes, Your Honor.
All right, I have an amended complaint that alleges that on or about May 24th, 2026, in the city of Manton for Wexford County, it is alleged that you committed the offense of, in count number 1, police officer, first responder, assaulting, resisting, or obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. And consecutive sentence may be imposed if it happened in a place of confinement. In count number 2, it's alleged that you committed the offense of 911 emergency telephone number information, unauthorized use or disclosure. That is a misdemeanor punishable by up to 180 days in jail and or a fine of $5,000. The people have also selected to charge you as a habitual offender second offense notice, meaning that you have at least one prior either attempted or completed felonies in your past. That makes that 2-year felony punishable by up to 3 years and the $2,000 fine up to $3,000. Do you understand those charges and the potential penalties?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
The appointment one.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea, and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove 2 things. 1, probable cause that the felony had occurred, and 2, probable cause that you were the person who had committed it. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to that preliminary examination will be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments and the threat that you pose to the community. Historically, counsel, I show in 21 a jostling conviction, 22 jostling, 25 assault and battery, and attempted carrying concealed weapon. Looks like there was also a couple of driving violations there as well. The praxis scores him at a risk level 2. Any comment regarding bond, Mr. Avento?
Thank you, Your Honor.
No, Your Honor.
Thank you, Mr. Dimitri.
Thank you, Your Honor. We would respectfully request a personal recognizance on in this matter. The praxis score comes out as 2, which the recommendation would then be release with condition supervision. Also considering he has low risk of flight, he owns his own. He reports that he owns his own home in the area, that his family lives in this area, and he has lived in this area his entire life. For public safety, he is more than willing to consent to any terms that the court would impose to ensure public safety going forward, pending further proceedings in this matter. And for those reasons, Your Honor, we would respectfully request that he personal cognizance or at least above 10%. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I do not have a police report at this time, so looking at the affidavit as probable cause, this is pretty concerning behavior. It does say in here that the defendant, when he did call 911, which was several times, at one point he began screaming and cursing at dispatchers and vaguely threatening them. Obviously, this eventually led to an RMO occurring between officers. I do think that there are some public safety concerns, especially with his recent assaulted priors. So I would ask for a monetary bond to be imposed in the amount of $10,000 cash surety.
What are the allegations of the RNO?
Troopers found him at a gas station after he had made several calls to 911. When they approached him, they advised he was going to be arrested. And backing up, officers told him to stop. Like he was going to throw a punch at one of the troopers. And then they essentially had to take him down to the ground, in which one time he got back up and attempted to flee.
Right, and I see he's on circuit court probation. Is there a probation hold on him? Do we know? Corrections, you know, does probation have a hold on Mr. Dimitri?
It says it in his file, they do.
All right. All right, given that the defendant is currently on probation for an assault and battery and an attempted CCW, given the allegations of the resist and obstruct as laid out by the prosecutor, I do find that the defendant does pose as of right now, threat to the community. Given that he currently has a hold on him, I believe it is appropriate to set a monetary bond. Monetary bond will be set at $5,000 cash surety, with the condition, Mr. Dimitri, that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Also, you are not to act in any threatening, intimidating, or harassing behavior. You are not to purchase or possess any firearms or weapons. Lawrence, is there any allegation of drug or alcohol use in this?
Not an affidavit that I can show.
Right.
I didn't do that, like they said, I didn't try to punch him or that.
Okay, Mr. Dimitri, you had the right to remain silent, so I suggest you use that right, because anything you say right now, the transcript could be obtained by the prosecutor and used against you. So just want to make sure you're not saying anything about the facts of the case, okay?
Okay.
All right, just making sure I got everything I believe I have. So, Mr. Dimitri, for right now, until we know more about your case, bond will be set at $5,000 cash surety, all right?
Great, thank you, Your Honor.
All right, thank you. Next arraignment.
Have a nice day.
Thank you, you too. All right, person at the jail, could you please state your name for the record?
Medina.
All right, this is case number 262057 SM, the people versus Devin James Medina. Mr. Medina, I know you met with somebody from Community Corrections and gave them a mailing address. Is that mailing address a valid mailing address?
Not anymore, it's not.
Do you have a place where you do receive mail?
No, never know.
All right, do you have a phone number or an email address?
I do not.
Okay. Did you have the opportunity to meet with somebody from the Public Defender's Office today?
I think they showed up, but I didn't speak with them.
Okay, you chose not to?
Yeah.
All right. I have a complaint that alleges that on or about March 25th, 2026, in the city of Cadillac in Wexford County, Michigan, it is alleged that you committed the offense of stray dog. That is a misdemeanor punishable by up to 3 months in jail and or a fine of not less than $10 nor more than $100. Do you understand those charges and the potential penalties?
Yeah.
You do have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
No.
Do you want to represent yourself then? Is that?
I guess so. I didn't know if it's is this really gonna be? It's really gonna be a thing? Like.
As of right now, that's what the prosecution has charged you with. So you've got 3 options. One is to hire an attorney, one is to represent yourself, or the other is to request the appointment of a public defender. How do you want to proceed?
I don't know. I guess I'll represent myself.
All right. Before we do that, I have to make sure that your waiver of an attorney is knowing and voluntary. So I have a form I'm going to read to you here. I guess, how many years of education do you have?
2.
2 years beyond high school?
No, 2nd grade.
Went through 2nd grade?
Yeah.
All right, Mr. Medina, this form says that I am the defendant in this case, and the judge has explained to me, and I understand that I have been accused of a crime, and I have read or have read to me the charges against me, and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I had the right to consult with the lawyer that I hire or that the court appoints. That I had the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and not get any special treatment from the court. That the risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection procedure or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. I have 2 years of education. I read and understand the English language. I am mentally sound. Having gone through all that, you still wish to represent yourself?
Yes.
And you can read the English language sufficient?
Yep.
All right. The court is, I believe the waiver is voluntary and knowingly, so I will allow the defendant to represent himself. Mr. Medina, you have a couple of options available to you today. One is to plead not guilty. If you pled not guilty, we would set the matter for a pretrial, which would give you the opportunity to discuss this case with the prosecutor to see if there's a way to resolve it. The other is to plead not guilty. If you pled not guilty, we would set, the other is to plead guilty. If you pled guilty, the 3-month misdemeanor would enter on your record and you'd be sentenced today. Do you understand those two options?
Yeah, how would I get sentenced today then? So plead not guilty?
Now, if you pled guilty, you would be sentenced today. If you pled not guilty, we would set the matter for a pretrial.
Okay, yeah, I'll plead guilty.
Sir, are you currently on a probation violation at all?
Yep.
So do you understand that if you pled guilty today, and this was the basis of the allegation, that they would be able to use that violation or your guilty plea against you for the violation? Do you understand that?
Yeah, I don't really care.
Are you sure about that?
Yeah.
All right, Mr. Medina, will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth. All right, you may put your hand down. Mr. Medina, has anybody promised you anything in order to get you to plead today?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes.
Ms. Lawrence, are you aware of any promises, threats, or inducements?
Oh, yeah.
Mr. Medina, I know you were on probation at the time. Were you on bond in any other file?
Not that I'm aware of, Your Honor.
All right. Do you understand that you have a right to a jury trial, the right to have witnesses called for your defense at trial, the right to cross-examine all those witnesses called against you, the right to testify or to remain silent, the right not to have that silence used against you, the right to be presumed innocent, and the right to be proven guilty beyond a reasonable doubt? Do you understand all those rights?
Yes, Your Honor.
Most importantly, do you understand that you do have that right to a jury trial, and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind? Do you understand that?
Yes.
And are you waiving your right to a jury trial?
No.
So you want a jury trial?
Yes.
So if you wanted a jury trial, that would be a not guilty plea, and we would then set it for a pretrial.
Okay, we'll do that now.
All right, we will then set this matter, we will enter a not guilty plea, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of your appearing at future court appointments and the threat that you pose to the community. Mr. Medina, based on what I've seen today, I'm not entirely convinced it's going to be in your best interest for you to represent yourself. So what I'm going to do is I'm at least going to request that the Public Defender's Office meet with you and see if we need to change your request for an appointment of an attorney, okay?
Okay.
So we will set the matter for a pretrial. You do have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Fervento, I know you did not meet with Mr. Medina, but you wish to weigh in on bond.
Thank you, Your Honor. We do have a praxis score, which is 3 to 6, but considering that it is a dog stray, Your Honor, we would respectfully request a BR bond. Thank you.
Thank you. Ms. Lawrence?
Your Honor, the praxis does indicate he has 12 failure to appears, which is extremely concerning. But I think that does go to show he's in flight risk. While I do understand it is a low-level misdemeanor, I will respond to the discretion of the court.
Thank you. I do see that the fail to appears are there, but in the end, we're dealing with a 3-month misdemeanor. So the court is going to release Mr. Medina on his own personal recognizance, which is his promise to come back to court. Mr. Medina, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you enroll in community corrections services. If you are able to be released, so if there is a probation hold released on you, you'll need to come over to community corrections, which is at the ground floor of the courthouse, and get signed up for the services there, which is essentially to see if you're in need of any community services and to help you keep track of your court dates. Okay?
Okay, Your Honor.
Mr. Medina, if you do get out because you don't have a way for the Public Defender's Office to reach you, if you do get released from jail, you're going to want to contact them, even if it's walking over to their office, to meet with them, all right?
Yes.
All right. Thank you. Thank you, jail.
Devin sat before the judge and thought he knew the way. He acted like an idiot and chose to go pro se. With second grade, his only school, he waved his rights goodbye. Without a lawyer in the room, his chances were a lie. Oh, the music swells and the record shows that acting foolish in the court is how the story goes. He wandered in without a clue and made a grave mistake. Don't be a fool and go pro se for your own safety's sake.